As part of our ongoing collaboration with Central Square Foundation, we are excited to bring to you the fifth and the final part of this series, where we will speak to educators and academicians who rely on the need for effective assessment techniques at key stages of a child's learning journey. These assessments form the backbone of the various learning interventions and activities carried out by a teacher in the classroom. The episode will be out tomorrow, the 26th of October. The conversation will be available on our website, indianexpress.com, and everywhere you get your podcasts. Make sure to tune in. To listen to the first 4 episodes of the series, check out the links provided in the description. Now, on with the show.
In this episode, we talk about why India might win significantly fewer medals in the next Commonwealth Games. We also talk about the latest data on stubble burning and how the practice affects Delhi's air quality. But first, we talk about the Supreme Court's latest verdict concerning the issue of citizenship. Hi, I'm Shashank Bhargava, and you're listening to Three Things, the Indian Express news show. Last week, the Supreme Court, in a landmark ruling, upheld the constitutional validity of Section 6A of the Citizenship Act. This section grants citizenship to immigrants who entered Assam before the 1st of January 1966. Now, the ruling not only holds importance for the northeastern state, but also has important implications for other larger issues around citizenship, including the powers that the parliament has regarding the matter.
So Section 6A of the Citizenship Act, it's a 1995 legislation. There is, of course, quite some background to it.
That's Indian Express's legal editor, Apurva Vishwanath.
Firstly, it applies only to Assam, and it is a legislative solution that came from a political process, which is signing of the Assam Accord.
Back in 1979, the All Assam Students' Union had launched a demand for the identification and deportation of illegal migrants in Assam. At the time, there was a threat to the indigenous population of Assam from the influx of people from Bangladesh, which had been formed only 8 years ago. So this became a mass movement. People from all classes joined in. And after a 6-year-long agitation, the historic Assam Accord was signed in 1985 between the Government of India and the leaders of the Assam movement. The accord essentially defined who was a citizen in Assam. And later, aspects of the Assam Accord were codified into Section 6A of the Citizenship Act.
Assam has a very fraught history with demographics, migration, and the politics of the state have been shaped around these conversations. So we have to understand 6A in that larger context. Just to give you a sense, for rest of India, there is no such provision particularly, except for Assam, because, like I said before, Assam's politics have been shaped through this. There was a larger political movement, protests, and the state has always demanded that a list of who are Assamese and who are migrants be drawn up. So for the rest of India, in a sense, the 1951 general elections and the electoral lists that were framed during that time, that sort of accounted for who's a citizen and who's not. But for Assam specifically, that wasn't enough. There was already a round of National Registry of Citizens that was conducted for Assam specifically. And of course, the idea to revive that happened very recently again. So Assam, in that sense, had a unique history, and this was only done for Assam.
She says that for Assam and the rest of the country, there were 2 kinds of citizenships that were accounted first.
One is whether you're already a resident of India at the time of the commencement of the Constitution, right? At the time when the Constitution comes into force, who is a citizen, that is sort of taken care of, which is essentially, you look at it from 1948, you should have resided in India for at least 6 months after that. And so by the time the Constitution comes into force, if you are a citizen, you are a citizen, right? And then we account for other people, which is the partition-related migration. There we say that some permits were given, so there are different timelines for that. But invariably, let's say by 51, these timelines sort of merge. But for Assam, the wave of migration continues till Bangladesh is formed, and even after that. Which is why the cutoff date is sort of taken for Assam specifically as 1971.
That was, of course, the year when Bangladesh was formed.
It's actually 1966 in one sense. Again, 1966, if you ask me why that specific date, it was just logistically deemed easier or more convenient to have that 66 date. So for people who entered Assam, say from 66 to 71, that intervening period, they could actually acquire citizenship.
All this was done by the then Rajiv Gandhi government. And the challenge before the Supreme Court was whether this date that was set just for the state of Assam was constitutionally valid.
So what is in question here is whether the parliament can bring in a law to alter citizenship laws. Does the parliament have the power to do so? And can it do that only for one state if required? This is just the broad question before the Supreme Court.
She says that first a two-judge bench referred the matter to a larger bench in 2014. This larger bench was formed earlier this year and delivered its verdict last week on the constitutional validity of Section 6A.
So 6A basically provided that prescription which said, if you came to Assam between these times, that is 66 to 71, you would be considered a citizen. So this is just before Bangladesh was liberated. People who migrated, moved in, those individuals would be considered citizens. So here the question was not whether, what happens to people who came in after 71. Rather, it's a different question. The petitioners in this case, you would say Assamese groups, wanted this cutoff date pushed at least, say, 2 decades back. What they were arguing for is to have the 1951 cutoff, like it is for the rest of India, right? But we see nearly 2 decades of migration is assimilated into the state. So the petitioners have argued really that it affects the rights of Assamese citizens, Assamese who live in Assam, their linguistic and cultural rights by this influx of migration. And of course, the larger question is, can the parliament make a law like this only for one particular state? So here the Supreme Court actually makes a specific case for Assam and says Assam's unique history, how pretty much of all of 19th century in Assam has been shaped by its migration politics. So, and the protests that happened in the 60s and 70s in Assam. So considering all of this, the Supreme Court says Assam was a unique situation where the central government needed to intervene and make such a law.
So the court upheld that exception, thereby saying that it is not arbitrary and does not violate the right to equality.
The second broader point is, of course, this determination of who is a citizen, right? We all have a fundamental right to protect, preserve our culture. But does that mean you say no to migration? So here again, the Supreme Court, in fact, for the first time in our jurisprudence, has this elaborate reading and understanding of what fraternity means. The word fraternity features in the preamble to our constitution, and we do consider it one of our constitutional themes of who we are as a nation. But the court, for the first time, sort of elaborates on what it means to have a fraternity. It doesn't mean that, we choose our neighbors. It doesn't mean that just because there are migrants that my cultural rights are sort of taken away. So the court brings in this broader canvas to define who is a citizen. So by allowing this, 2 decades of migrants into the state and making them citizens, the court sort of puts its stamp on what the government tried to do in 1985.
Right, and one of the things that the court observed in this regard was that the petitioners did not actually provide any proof to show that the influx of migrants affected the cultural rights of citizens in Assam.
Yeah, because the court's answer to this was you have to show evidence that your cultural rights are violated. It won't be taken as a blanket statement that the mere presence of migrants will lead to a violation of, a local person's cultural or linguistic rights. So that's there. But having said that, what it does is also legitimizes this political process, because at the end of the day, India's intervention in the creation of Bangladesh, India's role, one of the big impacts of that, or one of the big consequences of that, was this influx of migrants into the northeastern parts of India, right? Into especially Assam and West Bengal. So in Assam, the Supreme Court upholding Section 6A is an acknowledgement of all of that.
And Apurva, what was the court's counter in that sense to the petitioners saying that Section 6A violates the right to equality and that the date March 24, 1971 is just arbitrary?
So, why do we have the date of March 24th. It's because Pakistan Army's Operation Searchlight, which saw this massacre of Bengali nationalists and, of course, then compelled many to seek refuge in India. That began on March 26th. So anybody who came to India to escape that could be granted citizenship. That is why the date is there, right? So the court found a rational basis for this date. It's not all that arbitrary, but it follows that particular historical narrative. It is the day of liberation of Bangladesh. And after that, people who sort of came into India after 71, they are actually not deemed citizens at all. It is for them that the foreigners' tribunals exist. There are specific laws, which again we see in Assam, which we keep reporting about, where they have to show paperwork that their ancestors came to India before the cutoff date. In fact, in the judgment as well, the Supreme Court also makes this declaration that those who entered after the cutoff date are illegal immigrants. So they cannot be granted citizenship. But of course, that's a separate question. But the 25th March 1971 date itself, the Supreme Court says, is not an arbitrary date, that there is a reason to why this has happened.
And you mentioned that one of the key things that the court was looking at was whether the parliament can make laws that regulate citizenship. And in that context, we should talk about the Citizenship Amendment Act, which obviously has citizenship at its center. It aims to grant citizenship to migrants belonging to Hindu, Sikh, Buddhist, Jain, Parsi, or Christian communities, basically everyone except Muslims, who entered India before 31st December 2014 from 3 neighboring countries, Pakistan, Afghanistan, or Bangladesh. So when we look at this judgment, can you talk about how it could affect the Citizenship Amendment Act?
See, I think now politics of Assam itself perhaps has moved on from the Assam Accord and the citizenship of the Bangladeshi immigrants, so to speak. But this case and the ruling have a very significant impact on what is to come. There is a larger challenge also pending before the Supreme Court on the constitutional validity of the 2019 amendment, which you mentioned, where people of other religions, basically everyone except Muslims from neighboring countries who come into India before December 2014 will be granted citizenship. So this is actually Section 6B in the same Citizenship Amendment Act. Now that the court has upheld that Parliament has power to regulate this, the Parliament can decide who is a citizen. It seems like that's a big win for the state. Having said that, we will have to now see how the state or the government will justify this 2019 amendment in the face of the Supreme Court's judgment. Just for Assam. For the rest of India, it's still not a big issue. But now that you've said anybody who came to Assam post 71 is an illegal immigrant, right? It's a foreigner. Then how can you allow someone, even if it's a Hindu, even if it's a Christian or a Buddhist, how do you allow them to be a citizen because they came before 2014? This dichotomy of 6A and 6B, that will be played off. That's only in the context of Assam, sure. For the rest of India, it really doesn't matter. But even for the rest of India, when this challenge comes up to court, there are a couple of things that flow from this ruling. First is this idea of fraternity and how can you determine who is a citizen, right? The court's language of saying, you don't choose your neighbor. These are not things done in partisan ways. All of these will be very relevant when the government has to defend why it excludes Muslims against every other religion. That's something that the government will have to defend in court.
And what about the date, 31st December 2014? Will that pose an issue when it comes to CAA?
For Assam, the court really went into the history of the geopolitics around Assam and the migration there and the larger context of India's intervention in the Bangladesh war. But why 31st December 2014? That's something that the government will have to justify. So for Assam, it becomes a much more crucial challenge because again, remember Assam protests against migration are not targeted at one particular community. It is about everyone. There could be Bangladeshi Hindus who've come. It could be even the Marwadis, but it's about people who are non-Assamese. It doesn't matter which religion they come from. But for the court to uphold the 2019 amendment, it's a tall order for the government to defend these issues. The cutoff date, the reasoning for it, and also the reason for excluding Muslims. They will have to defend that in court.
And Apurva, in this case, the court was only examining Section 6A. But could you explain to our listeners who may not be familiar with the legal system why the court could not have considered Section B as well, since it also pertains to this issue?
So, yeah, that's an interesting question. But, as surprising as it might sound, legal questions are actually answered pretty clinically. There is a method to this madness, and the Constitution bench only answers the questions before them. And now it's up to a smaller bench to again go back to the issue, look at the NRC question, ensure that the NRC final list comes into place, all of these things for the smaller bench. This 6B question again, it's also a later cause of action. 6B only came in 2019, whereas the Assam Accord challenge in a sense has been pending since the late 90s. So that gets precedence, and of course, this bench was not hearing the 6B question at all.
And next we talk about the Commonwealth Games, which take place every 4 years. Now, during its last edition, India had won a total of 61 medals. And for anyone who follows the Games, this wasn't surprising at all. India usually wins over 60 medals. For example, in 2018, they got 66. In 2014, they won 64. And in 2010, they grabbed 101 medals. But it turns out in 2026, India might not hit those kind of numbers. And that's because 6 of the 12 events where India won medals last time have been dropped from the 2026 edition that will take place in Glasgow. These include badminton, cricket, hockey, squash, table tennis, and wrestling. When we spoke to the Indian Express's Mihir Vasavda, he told us the main reason behind this is money.
So, Commonwealth Games in 2026 were initially supposed to be held in the Australian state of Victoria, multiple cities including Melbourne. They presented a plan and set aside some budget for it. And a couple of years into their preparation, those guys realized that they'd miscalculated the whole budget and it was way higher than what was projected. So they said, humse nahi ho paega. They basically gave up, they surrendered the hosting rights. And it left the organizers, the Commonwealth Games Federation, in a state where they didn't have any other alternate hosts. They tried multiple countries. They tried Canada, they tried Malaysia, Singapore for a moment was considered. They even reached out to a couple of African countries. And everyone said that we are not interested in hosting this. So eventually, because in 2030, the Commonwealth Games will complete 100 years, and they didn't want that continuity to go away, they came up with a last gap arrangement where Australia, for not hosting these CWG, were made to pay a fine. And that fine gets around close to $100 million, something like that, 100 million pounds, $100 million, something like that. Using that fine, Scotland will be organizing the games. So not a single penny from the public money, not a single tax dollar will be used to host the Commonwealth Games in 2036. Instead, a bulk of it will be funded through the fine that Australia is paying. So in a sense, Australia is paying for the Commonwealth Games that are being hosted in Scotland, if that makes sense.
But considering that Australia is already paying for all of it, can't they host it themselves? Why does Glasgow have to step in?
So that's where the second part of your question will be answered. Now, Glasgow, they have stadiums and venues and the hosting experience from just 10 years ago. In 2014, Glasgow had hosted the Commonwealth Games. And as we see in Delhi, where a lot of venues that hosted the Commonwealth Games in 2010 are still being used for different events. So Glasgow is even younger in comparison. It's just 10 years. So they have a lot of stadiums which were used in 2014, which are in a ready state to host the games in 2 years' time. So there will be zero construction of new venues. And what they have also done is to keep the security and the transport costs. These are the two highest expenses, right, at the Commonwealth Games or at any sporting event for that matter. To reduce these expenses, the security and transport expenses, they have chosen the 4 venues which are within an 8-mile radius. So all those costs are saved. And instead of constructing a massive athletes village, they have chosen hotels where athletes will be put up. And those hotels are maybe in walking distance to some of the stadiums or most of the stadiums. So you reduce costs over there. Now, I'll kind of ramble on for a minute more. One of the main reasons why a lot of these sports, especially team sports, have been chucked out of the 2026 edition is they didn't fit this plan. You know, the 4 stadiums, the 4 venues that were chosen were not a part of these. I mean, they could not host these games. Say, for example, the hockey stadium was far off. Similarly, the cricket stadium wasn't a part of this. So, yeah.
Okay, so usually, and we see this during the Olympics as well, usually they first select the sports and then build the infrastructure required for it. But this time, what they seem to have done is look at what venues they already have and then selected the sports accordingly.
So, yeah, in that sense, the Glasgow Games could be a trendsetter where the venues that are available, they're choosing sports based on that rather than doing the other way around, where you pick a sport, you decide your sports program, then decide whether you have venues or you have to construct them. And, at a time when the whole relevance of Commonwealth Games or the multidiscipline games overall, right? From cost point of view, from the environment point of view, there are multiple factors that the multidiscipline games are criticized for. In that sense, who knows, this could be the template. Like there are arguments on both sides that this is the start of the end of the Commonwealth Games, bringing it down to just 10 events. And then there's this other school of thought which says that this could actually be a template for the future hosts where you can reduce costs and still have a games-like atmosphere.
And Mihir, these sports that have been omitted, how big of a deal are they for India?
The sports that are omitted, say if we look at only the 2022 edition of the Commonwealth Games, 6 sports from those. So India won medals in 12 disciplines, 12 different disciplines, and 6 of them. So half of the sports where India won medals, they won't be there in 2 years' time in 2026. And those 6 sports contributed to 37 out of the 61 total medals that India won. And if we kind of again sit and calculate, those 6 sports is also where majority of India's participation numbers would be. So come 2026, you'd be looking at a scenario where the Indian contingent size will be smaller than ever, perhaps, in at least recent history. And the medal count would reduce drastically. So you're now left with practically 2 sports, athletics and weightlifting and boxing to a certain extent, where you can expect a bulk of medals. And there's absolutely very little chance of India medaling in, say, something like a swimming, cycling. I don't think India has a team in netball. So those are the sports where India would not be even competitive or India would not even have athletes participating.
And what about the Commonwealth Games themselves? How important are they for Indian athletes?
The relevance of it is questioned every 4 years. So the whole chest-beating patriotic side of argument is that why do you want to be reminded of being someone's colony every 4 years? So that's one side of the argument. The level of competition in some sports like hockey, sports like, top of the head comes boxing, swimming. These are the sports where the level of competition is pretty high. And Indian winning and medal. Remember Avinash Sable, what happened in 2022. He challenged the whole dominance of Kenyans at the Commonwealth Games in steeplechase and became like the big story of our generation, our times. So those kind of stories still are relevant in Indian sport, which is trying to kind of find its feet. India is still not big at Olympics, but it's quite big at the Commonwealth Games and the Asian Games. So from that point of view, those games are important. And lastly, from purely financial point of view, the Commonwealth Games are important because the athletes are rewarded big time for winning medals at the CWG. In fact, I think even the 4th place finishers were given some 15 lakh by the Haryana government last time. So, financially also it's kind of a big deal.
And Mihir, right now what seems to be happening is that one country or one city is having to bear the burden of hosting all these games. Instead, can't we have all these games sort of spread across different countries so that no one country has to bear the entire load?
So what, in a sense, you're saying is it's existing already. There are Commonwealth championships for each sport. So, for example, Delhi would host the Commonwealth weightlifting championship. Then there would be like some Commonwealth different sport championship in another country. It's not, for each and every sport, but it's there. The beauty of, having all sports in one city at one time is also the coming together of it. Individually, it's all there, it's scattered, but you don't kind of take notice of it. Once, you have these 15, 20 sports in one city, you see the whole mood of the city changes. There is this sense of anticipation every 4 years of something like this happening. There are so many sports, say, for example, a lawn bowls. You wouldn't think of lawn bowls in normal day and time. If it was a standalone lawn bowls Commonwealth Championship, you wouldn't even pay attention to it. But because it's happening in the 2-week period of the Commonwealth Games, you'll notice a sport like that. So for a lot of fringe sports, even say for that matter, a sport like hockey, We consider it big in India. It's one of the mainstream sports in India. But you look at it in Australia or in England, it is a fringe sport. It is a niche sport. So for sport like hockey as well, to be a part of the Commonwealth Games and to be seen along with athletics and swimming is a big deal. So that's why it's important to have an event like this. I'm not saying just the Commonwealth Games, but even the Asian Games or the Olympics for that matter. A lot of these niche sport, they have their moment under the sun.
And in the end, we talk about stubble burning. Every year, around this time, farmers in the north harvest the paddy crop. And after harvesting it, the crop leaves a small stubble on the ground. Now, to get rid of the stubble before the next crop can be sown, the farmers set it on fire. The smoke that rises from this fire increases pollution not only in the surrounding areas, but is also known to worsen the air quality in Delhi. Now, the most amount of stubble burning takes place in Punjab, followed by Haryana. But this year, UP seems to have taken Haryana's place. The Indian Express's Mallica Joshi tells us how these fires are tracked.
So IARI, which is the Indian Agricultural Research Institute in Delhi, they have a laboratory which monitors fires, other events as well, but fires for this particular case in paddy fields for this season. They do this through satellites. And over the past 4-5 years, they've been coming out with data on which state has how many fires. They have district-wise data. This was done after, the issue of farm fires became big, and it became something that was very concerning for Delhi. And the courts over the past few years raised the issue of how this needs to be controlled, and there needs to be a very dedicated plan to tackle paddy stubble burning.
Right, and Mallica, can you tell us the extent to which stubble burning actually affects Delhi's air quality?
So, it actually depends on a lot of factors. It's not as simple as saying that, if there are very high number of fires in Punjab, Haryana or Uttar Pradesh, it will automatically lead to a deterioration in Delhi's air quality. The biggest factor that it depends on is the wind direction. So if the prevalent wind direction is from northwest, it means all the smoke and the, residue from these states, from Punjab and Haryana, will come towards Delhi. And on the other hand, if the wind direction is easterly, then we get the load of pollutants from Madhya Pradesh and Uttar Pradesh. In fact, in the past, it has been seen that when the direction is northwesterly, we can get, not just stubble fire smoke, but also dust from as far away as the Middle East sometimes. That's how these wind systems travel. So in any case, in Delhi, the problem of pollution also has a lot to do with where it is located and the weather conditions during this time as winter starts to set in.
Yeah, and it's the end of October right now, and Delhi's air quality is already in the very poor category. Is it expected to further worsen as we near Diwali?
Yeah, so that is a concern for sure. This year, October has been better, especially the first half of October, but we've seen a clear deterioration, especially over the past week. According to forecasting models, in the next 1 week, it is expected to get worse. So there are several reasons for this. The farm fires are supposed to peak in the coming few days. Then the temperatures are going to fall, both of which actually lead to, a dip in Delhi's air quality. The winds during this season are pretty calm. So while, of course, there are winds that are carrying these the smoke and the residue from these areas, we need strong winds to blow away the accumulated pollutants. And we don't really see that in winters.
And Mallica, over the last few years, there has been a lot of focus on imposing fines and incentivizing the sale of paddy stubble. Have those measures helped at all?
So, if we look at the data since 2020, that is when the data is available since, we do see a clear dip in the number of fires. So, for example, if we take the case of Punjab, and this data is from 23rd of October, in 2020, between 15th September and 23rd of October, we had almost 14,000 farm fires. This year, Punjab has seen the lowest number of farm fires for now in this duration, which is at 1,638. So there is a very clear dip. So we've gone from essentially almost 14,000 to almost 1,600. So that's a very significant dip. In Haryana as well, Haryana actually saw the highest number of farm fires in 2021. Again, we're talking about the time period between 15 September and 23rd October. It was 1,726 in 2021. This year, so far, in this duration, we've seen only 680 farm fires. The concerning thing is that UP has seen almost a reversal of trends. The highest before this year it had that UP saw was in 2020 at 670 fires. This year we're already at 808. So in the cases of Punjab and Haryana where, the focus has been largely because the numbers have been very high, especially in Punjab, we can see that there is some change for sure. Because each year we've seen the number of fires reported through this portal drop.
You were listening to 3 Things by the Indian Express. Today's show was written and produced by me, Shashank Bhargava, and was edited and mixed by Suresh Pawar. If you like the show, then do subscribe to us wherever you get your podcasts. You can also recommend the show to someone you think will like it, share it with a friend or someone in your family. It's the best way for people to get to know about us. You can tweet us at Express Podcasts and write to us at podcasts@indianexpress.com.